My name, as Carl mentioned, is Jay Salpeter. I'm a retired New York City detective, and I was Martin Tankleff's private investigator. I was the investigator involved, and I was the investigator to help Marty, of course, be free. But I was just a member of a team, okay, and I stand before you, and I'm going to be a representative of Marty's team, but it was not only me. I mean, Marty had a phenomenal support group. And before I start, I just want to thank some of the people. I mean, Marty's attorneys who worked pro bono for Marty, Bruce Barquette, Steve Bryant out in Washington, Barry Pollock, plus about 20 other attorneys, if not more. I also want to thank, without Eric Friedman, who's here today, and Lonnie Suri, Marty had a phenomenal public relations team. And they kept the case out of the public, and because of that, Spoder and the Suffolk County District Attorney's Office, they couldn't keep it quiet. These people, if it wasn't for them, it would be phenomenal. I want to thank Bruce Lampert. He was a reporter for the New York Times that covered this case. This gentleman back there holding his hands with the blue shirt. And then the greatest people that Marty should thank for his 18 years in jail was his family that stood behind him, that supported him, that were there every day, came to court every day, fought for him, accepted phone calls for all the years, and came and fought for Marty's freedom. And we're lucky enough tonight to have Carol and Ron Falvey, Marty's relatives. These are just some wonderful people. Unfortunately, the McClaws, they were in San Francisco, they couldn't make it tonight. Now, most of you all know the Martin Tankleff case, right? So, I mean, right now, I'm not going to go over the whole case with you, but I want to go backwards. I want to start backwards and then work to Marty's case. I'm going to read to you a couple of things. You're going to see at the top of my head for a while, and then I'm going to get up and speak to you. But this is from Barry Scheck. Barry Scheck, right now, is doing Marty's civil case. And there's things here that you're possibly not aware of that I'd like for you guys to hear. On June 11, 1979, the National Law Journal published a front-page article detailing the widespread practice of coercing confessions among the homicide detectives of the Suffolk County Police Department. The article described use of physical force and other improper techniques to pressure suspects to confess, as well as a startling failure to follow up on obvious leads inconsistent with the confession or to seek evidence that might corroborate or refute the confession. This is the beginning of the lawsuit. In response to the National Law Journal article in Suffolk County, the Bar Association conducted an extensive investigation that included public hearings. In a report issued in January of the 80s, the Bar Association found serious problems with the way Suffolk detectives conducted interrogations, the unlawful use of physical force, and a failure to investigate complaints of misconduct internally. It recommended, among other reforms, a videotaping of interrogations. Now, Marty asked for his interrogation to be videotaped, and Marty even asked for a polygraph, which was declined. The Newsday report has compared confession rates in 6 comparable counties and found confession rates between 54 and 73% in those jurisdictions. In Suffolk County, it was 94. 94% of that homicide arrests were based on confessions. Between 75 and 85, the New York Supreme Court Appellate Division reversed 10 Suffolk County murder convictions because homicide detectives had used illegal tactics to elicit confessions. As early as 1979, Suffolk County policymakers were aware of a stunning pattern of unlawful behavior in the way homicide detectives obtained and reported confessions. By 1985, Suffolk County policymakers also were on notice of the egregious, misconduct by a detective named James McCready, who was a lead detective in Marty's case. In the early 80s, a young defendant named Timothy O'Toole challenged the admissibility of his confessions on grounds of coercion. O'Toole argued that he confessed only after McCready kicked him in his testicles. The attorney assigned to represent O'Toole at arraignment testified under oath that he had observed severe bruising on and around O'Toole's testicles. McCready denied it. In 1985, Suffolk County Police testified against a man named James Diaz, whom homicide detectives claimed had confessed to a brutal rape and murder. This one you gotta hear. Diaz refused to sign the confession. McCready testified at the trial that a witness identified Diaz from a photograph in the newspaper. The defense impeached him by showing that no paper ever put his photograph in the papers. McCready then claimed that he had just assumed the witness had seen a photograph of Diaz. Caught in a lie and confronted by the trial judge, McCready went on to falsely claim that he showed a photo array to the witness. No photo array was ever documented or reported, and in fact, the prosecutor had already told the judge that no photo array procedure took place. The detectives claimed that Diaz confessed to the rape and murder and said that he ran out of the house where the crime occurred and discarded a knife in the woods that he used in the murder. Police had recovered the knife in the woods. They recovered the knife. 10 months after the confession, the victim's husband found a bloody knife in the basement that was determined to be the murder weapon. Yet, Suffolk County policymakers stubbornly refused to acknowledge or remedy the ends justify the means approach of their detectives, despite the clearest possible from the press and the judiciary. That's from Schex, from his lawsuit. Marty's parents, as we know, were unfortunately murdered September 7, 1988. Marty awoke to see his father, unfortunately, on the doorsteps of death, with his, throat slashed and stabbed, and then eventually he found his mother brutally murdered. On April 23rd, 1990, to June 2nd, 1990, Marty went through a trial and he was convicted based on a confession that not one thing hit the crime scene. Not one thing in the confession. Marty never wrote out the confession. Marty never saw the confession until later on. And he was convicted on this. On December 20th of 2000, December 21st of 2000, I received a letter in the mail when I came back from vacation. I opened it up in January. There was a letter from Martin Tankleff to me asking me if I could work for him. All of Marty's legal remedies were exhausted. He was finished, done, kaput. He had attorneys from Nixon Peabody, Baker Bottoms. All the top firms in this country worked for Marty pro bono. I don't know if you're aware of that. And Marty asked me to work for him pro bono too. Unfortunately, I wrote Marty back that I'm not as liquid as Nixon Peabody and the other firms. And I met with Ron Falvey, and I took a $5,000 retainer, and this was early in January of 2000. The letter was dated December 21st of 2000. On December 21st, 2007, 7 years to the day, the New York State Appellate Court overturned Marty's conviction. Today Marty is out. Today Marty is in law school. During the course, when I came into the case, I did an investigation. And for those of you not in the legal community, we needed to get the case back into court, and to do that we needed a 440 motion. A 440 motion basically is evidence, newly found evidence, that if it was found during the time of the trial, Marty could have been let go, he could have been acquitted, or there might not have been a trial. This 440 was supposed to last, they gave us 2 to 3 weeks to do this. It started July of 04, it ended in 06. Now, prior to going into the 440, we were told, and this is the United States of America, we were told the day that we were going to start at this 440 hearing with some of the witnesses that I found, that we were going to lose. And you know what? They were right. On March 17th, which was probably a great St. Patrick's Day for the fellows out in Suffolk County, of 06, Marty's was denied. And Marty had to stay in jail. Then we took the case to the appellate court. I just want to read just a couple of things from the appellate court. It is important to our sense of justice and fair play to countenance the possibility that someone innocent of a crime may be incarcerated or otherwise punished for a crime which he or she did not commit. A motion pursuant to CPL 440 is a vehicle which enables convicted defendants to fully vindicate their rights. With regard to his motion to vacate the judgment of conviction on the basis of newly discovered evidence, the defendant was required to show that the motion was made with due diligence after the discovery. The county court found that the defendant failed to make this motion with due diligence. We disagree. This is the appellate court, who unanimously overturned his conviction. 4 judges unanimously. This is part of their ruling. A review of the record on appeal reveals that the county court's determination amounted to a misapplication of its gatekeeper function relative to the evaluation and admissibility of the proper due evidence. The resolution of the inquiry into whether the evidence adduced at the hearing is of such character as to create a probability that such evidence been received at the trial, the verdict would have been more favorable to the defendant. Is dispositive of a court's determination of a motion pursuant to CPL. In carrying out this task, the hearing court is obligated to conduct a critical analysis of evidence. It cannot merely engage in the mechanical exclusion of such evidence. The county court completely, meaning Suffolk County Court, completely disregarded a crucial fact which is pivotal to our determination. Namely, many of the witnesses who testified at the CPL 440 hearing were unrelated to each other, and their genesis as witnesses was separated by both space and time. Moreover, a court must view and evaluate all of the evidence in its entirety. In its determination as to the impact of evidence unavailable at trial, a court must make its final decision based on likely cumulative effect of the new evidence it has been presented at trial. In this case, the county court failed in this regard. Instead, it erroneously applied both a narrow approach and methodically in evaluating the evidence. It appears that the county court never considered that the cumulative effect of the new evidence created a probability that had such evidence been received at the trial, the verdict would have been more favorable to the defendant. County court, in effect, applied a blanket disqualification of all the defendant's proffered evidence. If you don't know, a lot of my witnesses were basically at criminal pasts. So the court in our country, the judge and the DA would call them nefarious scoundrels. That's how they were branded. But when the DA would bring in Gravano, they're witnesses. We had a priest that was called a nefarious scoundrel too that testified. At the end of the decision on a related topic, we reject the people's assertion made at the oral argument of the instant appeal that certain witnesses came forth because this was a highly publicized case. That claim, that intense media coverage somehow played a role in this case to support the motion. With regard to the motion to vacate the judgment of conviction on the basis of newly discovered evidence, the defendant was required to